You ever had a silly argument with a neighbor? About where to put a trash can or how high a fence should be. We've all been there. But what happens when a simple disagreement over a backyard swing set just completely spirals into a full-blown legal battle? Well, that is exactly what went down in Blue Ridge Estates. And today, we are opening up the case file on this wild standoff. I mean, that sounds kind of ridiculous, right? But for this one community, this became a serious legal question that went all the way to a judge. It really makes you think, when you buy a home in a neighborhood with rules, what are you actually agreeing to? Could the playground you build for your own kids actually be against the law? So let's meet our players. On one side, you've got the homeowner, Charles Mandela. His whole thing was, the rules should be read and enforced exactly as they are written, period. On the other side, the Blue Ridge Estates Homeowners Association, the HOA, who argued, hey, you gotta look at the spirit of the rules, not just the words on the page. It's that classic battle, right? The letter of the law versus the spirit of the law. Okay, let's dive in. We're going to start with Mr. Mandela's case, which honestly all comes down to one very specific and pretty powerfully worded rule. So yeah, this entire fight, it boils down to this single sentence from the community's rulebook. It says pretty plainly that only one other structure, a garage, can be built separate from the main house. So if you read that literally, it means if you have a detached garage, any other structure, a swing set, a shed, a playhouse, it's a violation. Seems pretty clear-cut, doesn't it? And just so we're all on the same page, these CC&Rs, they aren't just, friendly suggestions. No, they are legally binding documents that every single homeowner agrees to when they buy a house there. They are, quite literally, the law of the land in Blue Ridge Estates. Now here's the thing, Mr. Mandela had history on his side. This wasn't some new fight he was picking. For more than a decade, the HOA had a track record of strictly enforcing this exact rule. They had forced people to take down gazebos, playhouses, even an observation deck. So his argument was pretty simple. Why on earth were swing sets suddenly getting a free pass? So that's the homeowner's case, and you got to admit, it seems pretty airtight. But the HOA, well, they didn't even really dispute the wording of the rule. Instead, their entire defense was built on a completely different idea, what the community was all about in the first place. So they pulled out this quote directly from the community's founding documents. The HOA argued that, look, from day one, Blue Ridge Estates was designed to be a place for recreation, for families. And they asked, what could possibly be more in line with recreation than a kid's swing set? And this wasn't just some vague theoretical argument. Oh no, the HOA showed up with a single, really powerful number for the judge, 16. That's how many families already had swing sets or play structures in their yards. Banning them wouldn't just affect one family. It would totally change the feel of the entire neighborhood. And this was the heart of their argument. The HOA claimed that one structure rule was never about playgrounds. Its real purpose was to stop somebody from, say, building a second house, a rental unit, or a little guest house on their property. And they had another rule that backed this up, which basically said if you can live or sleep in it, you can't have it. A swing set, they argued, pretty clearly doesn't fit that bill. But this is where things got really messy. The HOA board voted to formally clarify that, yes, play structures are allowed. Simple enough, right? Well, a typo on their website made it look like they had changed the actual CC&Rs, which is a huge deal that would require a massive 75% vote from all the homeowners. What they actually did was just tweak the architectural regulations, something they were totally allowed to do. But that simple typo, it poured gasoline on the fire and made it look like the board was secretly trying to pull a fast one. So there you have it. You've got a clear rule and a long history of enforcement on one side. And on the other, a community's founding vision and a plea for just a little common sense. With all the evidence out there, it all came down to one person, the judge. After hearing both sides, the judge made the call. Charles Mandela's petition was denied. The Homeowners Association won. The 16 swing sets, they could stay. So why? Why did the judge rule this way? Well, it all came down to one thing, intent. The judge basically agreed with the HOA, saying that the purpose of the rules, when you look at all of them together, was to stop people from building second homes, not to ban play equipment. The court decided that since a swing set obviously can't be turned into a place to live, the HOA was perfectly within its rights to clarify that they were allowed. So a little neighborhood dispute over swing sets is settled. Case closed.
But this small case points to a much, much larger question that affects pretty much anyone who lives in a community with a rulebook. And that's really the question this whole thing leaves us with. Is it more important to enforce rules exactly as they're written, just to be consistent and predictable, or is it better to interpret them based on their original intent, allowing for some common sense and flexibility? There is no easy answer. And as this case shows, getting that balance wrong can be the difference between a peaceful neighborhood and a trip to the courtroom.